Welcome to Immigration Insider with your host, Attorney John Nicelli. This podcast is an educational forum on how to deal with complex aspects of immigration and pitfalls to avoid. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Now here's the host of Immigration Insider, Attorney John Nicelli.
Hi, everyone. My name is John Nicelli. I'm an immigration lawyer for more than 42 years, practicing exclusively in the field of immigration law. And today I want to speak about a special rule and law that's in effect, affecting basically children who are under 21 years old and have been abandoned by or abused by their parents. So the rule was put in effect a couple of years ago, and it's actually helped thousands of children who will eventually become permanent residents once you go through the process. So basically, it's a special way for immigrant youth who cannot be reunited with one or both of their parents due to abuse, abandonment, or neglect. And abuse, abandonment, or neglect is defined in many, many ways. I mean, you could be abused, for example, in your home country, or even in the United States for that matter, but you have to be abused by one or both of your parents. And abuse can involve, for example, telling a child, listen, you can't go to school anymore, but you have to go to work in order to support the family. That's abuse. Maybe treating them harshly, not feeding them properly, keeping them, in detention for long periods of time. There's many, 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 many different types of abuse. And there's also many different types of abandonment. So abandonment generally is that you have no contact with a parent for generally more than 6 months. Abandonment could happen in many ways. Maybe you left the country and you have no contact with your parents anymore. And you left because your parents wouldn't support you. They had no money to support you. So they said, well, if you want to go, just go. So even though you left, it's considered abandonment. So there's many different forms of abandonment as well, which I can't go into all of them for the purpose of this podcast because it's too short. But if you would speak to myself or any qualified immigration lawyer wherever you live, they could probably go into a lot greater detail. One of the requirements for qualifying for a special immigrant visa is you must go to a state court to obtain a guardianship petition. And the guardian could be your parent who didn't abuse you or someone else. And that guardian generally has to be a person of good moral character, have no criminal record, things like that. The requirements for the child to get the special immigrant juvenile visa would be you have to be unmarried. You have to be under 21 at the time of filing with the SIJS. You have to be abused, abandoned, or neglected, generally be of good moral character, and it would not be wise for you to return to your country where you left. Now, age is a big problem. And the reason why age is a big problem because immigration requires that the petition be filed before age 21. If you're over 21, you cannot file with immigration. However, state courts vary, and there's different rules in different states. Now, most states have a residency requirement. For New York, you have to be 6 months living in the state. Some states have less of a requirement. I don't know all the requirements for all the states, but it varies from state to state. One of the problems we have is that if you take a state like Alaska, Arizona, Arkansas, you must go to state court, and the state court must sign the guardianship petition before your 18th birthday. If they don't sign it before your 18th birthday, you do not qualify in that state. In Alabama, for example, it's your 19th birthday. Now, different states have different rules, as I said, because some states require, like Maryland, for example, if you're age 21, under 21 rather, you can file the guardianship petition. However, the abuse had to take place before you turned 18. So it varies from state to state, and there's many different aspects of what's involved. So you always have to speak with a qualified attorney that really knows what they're talking about as far as guardianship is concerned and the special immigrant juvenile visas. Basically, you have to be, as I said, unmarried. Whether you have a lawful entry or unlawful entry doesn't matter. Whether you worked unlawfully in the United States doesn't matter. And you can even have certain immigration violations which would not disqualify you. Now, once we have a petition, a guardianship petition signed by a state judge, and you're under 21 years old, then you'd be eligible to file the petition with immigration. Now, the state courts vary in time as far as processing times. Most state courts are probably at least 4 to 6 months. Many states also do a background check of not only the guardian, but any adult that's living in the household with that child. So they want to make sure you're not living with another abuser after you've been abused or abandoned already. The petition, which is called a Form I-360, I believe it's 900 some odd, 925 is the filing fee right now. So around 925. The petition is filed with immigration. Generally takes a few months up to a year to be approved. The problem is that once the guardianship petition is filed with the I-360 with immigration, and immigration approves the case, you still have to wait till the visa becomes available. Now, currently in New York, for example, well, actually nationwide, the petitions are processed at processing centers in the United States that immigration has. And those processing centers take a long time, probably 6, 8 months or longer to approve a petition, sometimes over a year. The bigger problem is not getting the petition approved, is for the visa to be available. Now, once the visa is available, which now the processing time is at least 2 to 3 years waiting for visa availability, then you can file adjustment of status. Now, adjustment of status can also take a long time. Here in New York, adjustment of status is now taking close to 2 years. So first, the guardianship petition in state court. Once it's approved, you file the I-360 with immigration. And once that's approved, then you have to wait for a visa to be available, and then you file for adjustment of status. And the adjustment of status varies from state to state, city to city. The smaller the city, the smaller the state, the likelihood, the faster the processing time. The bigger the state, like New York, Illinois, Miami, Chicago, Texas, different cities in Texas, California, very long processing times, and upwards of 2 years or more to do adjustment of status. The good part about filing adjustment of status is that if you entered illegally, normally you can't adjust status. However, if you have a petition approved, the I-360 petition approved, recognizing that you have a guardianship petition and you're an abused child, you are exempt from the normal requirements of adjustment of status. So if you have an illegal entry, it doesn't matter. You're exempt basically from all bars to adjustment of status. The only bar you're not exempt from would be if you're a terrorist. If you're found to be a terrorist, you can never file adjustment of status based on a guardianship petition. As I said, it's a very complex process as far as adjustment of status is concerned, and it's also complex with the guardianship petition. There are many, many, many factors involved, and to be qualified, you can't lie. You must be telling the truth. You must show how you've been abandoned, why you were abandoned, and there's many, many reasons, as I said, why people are abandoned or abused. I've heard some real horror stories. Often a state court will want further verification of what a claim is. So when you go to state court, depending on who the judge is, some judges are very sympathetic to the situation. Some judges are not as sympathetic to the situation. So sometimes that could be problematic. And also state courts are, many are very backlogged. In New York, you're probably talking 6 months to get a guardianship petition signed by a judge. And the child must be under 21 in New York State. But in many other states, you have to be under 18. Some states 19. It varies from state to state, as I said. So that's pretty much what involves getting the petition and getting it approved. Another benefit you have is that once the petition is approved and you file adjustment of status, you'll become a permanent resident of the United States. And then 5 years later, you can file for U.S. citizenship. The only disadvantage that I know of SIJS status, we call it SIJS, which is the short for Special Immigrant Juvenile Visa. Basically, there are no derivatives. So if you have a guardianship petition based on abandonment, abuse, or neglect, you can never, ever file for your parents. So even if you become a U.S. citizen, even if you want to file for the parent that did not abuse you and took care of you and perhaps is even your guardian, you cannot file adjustment of status for that parent. If you have a child, there are no derivatives for any children. Normally, children under 21 are derivatives of many types of petitions. In that case, it's barred. It does not apply. So there's no derivatives, either parents, spouses, or children. There are absolutely no derivatives whatsoever. That's the only real disadvantage of it, because you become a legal resident, which is wonderful, but you can't help any family member. That's the only disadvantage. Other than that, I think I've covered the basics. Again, for naturalization, you still have to meet all the criteria for naturalization. So you have to have the 5 years, you have to be a good moral character, the physical presence, living in the state. You can't travel outside the United States for long periods of time, because to become a citizen, you have to be 5 years a resident and 30 months out of the last 5 years physically present in the United States. That's basically the requirements to become a citizen. And of course, good moral character you can't have. Even though you may qualify for a SIJS visa or a Special Immigrant Juvenile Visa, if you have a minor criminal record, sometimes when you become a U.S. citizen and they check your background, if you have a criminal record, you could be denied as a matter of discretion, depending on the type of crimes that you may have committed. God forbid you even committed a crime. And that's basically it. All right. So if you have any questions or you're interested in starting a case, please feel free to call us. We're at 225 Broadway in Manhattan, Suite 1040, New York, New York. The zip is 10,007. You can always send us an email at john@johnnicelli.com. That's john@johnnicelli.com. And you can call our office at 212-227-8020. As I've said, I've been doing this for over 42 years. I practice exclusively in the field of immigration law. We've had many, many, many clients who have filed for this. We have many that have already finished their cases. And it's really a good benefit for children under 21 years old. In some cases, they have to be under 18 in order to get the petition done, the guardianship petition done. So, and that's basically it. So I wish good luck to everyone. If you're interested, please give us a call. Thank you.
You've been tuning into Immigration Insider with your host, Attorney John Nicelli. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, johnnicelli.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.